Thank you very much for the introduction, and can I just say that although I would love to say that the book on child migration is written, it's in fact a work in progress. So it's been a fairly difficult gestation really in terms of just collecting the array of information that is needed in a book of that kind. I think that what inspired the book was just the sort of work that I get asked to do endlessly, and the very clear knowledge that there are just so many cases in the family division where immigration surfaces in one form or another. You certainly get the array of cases where people have actually initiated the family application expressly to get an order that is essentially an order that is needed for a visa application. And those, and that is because many of the criteria in the immigration rules and also the policies that the Home Office has devised require people to have particular types of family orders in order to establish the sort of family relationships that base their visa application. So, for example, you know, the recognition of an overseas adoption is a requirement in order to bring in an adopted child if the adoption is not automatically recognised under the provisions in Section 66 of the Adoption and Children Act. You've also got essentially requirements for things like a valid divorce, and so you may have to get various declarations in the family division. And the other sorts of cases are those where it's not a particular criteria for the visa class, but certainly some of the evidence that you may well derive from the family division is going to be enormously useful potentially for your visa application. And those cases are really significant. You get your FGM cases now, your forced marriage protection. You have, again, some of the domestic violence is a very common application made with an eye to a visa application that is going to be put forward by the visa applicant, and also the parents seeking contact with their children as part of a family life claim. So those ones again have immigration issues embedded in the case, if not the express focus of the case. And then you get other cases which may be private or care proceedings where immigration issues arise in the course of the proceedings, generally as part of the placement decision for the child. And so you get very often issues arising because the good enough parent is a person who is here with irregular immigration status, or you may have a carer abroad or potential carer abroad who you need to get a visa in order for them to be brought in for assessment. Or you have an EU national who's economically inactive, and so their immigration status comes up for consideration because they're not covered by free movement rights under the EU directive. And in those sorts of cases, what you're looking at is not just potential immigration status and whether or not the parent and child can remain here, but also whether the parent and child can remain here and access welfare benefits, and in particular housing assistance and housing benefits. And increasingly with the numbers of cases where you're considering moving a child into a different jurisdiction, and in particular placing a child abroad for adoption or a child abroad with an SGO, again, the immigration issues arise not in the context of necessarily the UK, but they definitely arise in terms of whether or not the child can enter and settle in the country where the proposed carers live. And so these, so many of the cases that we get asked to advise on are in fact cases about foreign law, and what is needed is a Polish or a German or a Sri Lankan or Indian lawyer rather than necessarily a person who knows UK immigration law. And then the only other cases that I just briefly allude to are cases that you don't see so often now, but I think are still somehow in the system, possibly at a first instance level, are cases where there's really no genuine dispute or no real benefit to the child from the family application, but you have a parent who is desperate to delay or prevent removal, and so they are seeking some sort of family order in order to, as I say, to delay or stop that. And the other line of cases, which has been going on now for really 20 or 30 years, are those adoption cases where you have an adoption by a British citizen and the child will obtain British citizenship by the adoption, and you have a whole history of the Home Office intervening, or the Secretary of State intervening in those cases, seeking to stop the adoption on the basis that it is somehow undermining immigration controls to give an adoption order in those particular cases. And the demarcation in those cases is very clear, that the family court looks at its own jurisdiction and the issues invoked in its jurisdiction, rather than necessarily acts as a policeman for the Home Office. What I wanted to focus on this evening is the arrangements that have now been in place for a few years but are not necessarily very well established, and those are the arrangements for some sort of cooperative working either between parties in the Home Office or the Court of the Home Office or indeed the parties and the immigration tribunals. And the first point, I think, is really an important one to think about, is whether or not you should contact the Home Office, and if you do, the sort of information you might disclose to the Home Office, and the sort of information you can generally succeed in getting from the Home Office. And all of you will be familiar with the protocol, the EX 660 forms that allow you to seek information from the Home Office. And in my experience reading them, they're very spare replies in most cases and barely informative. And it always seems to me that the most sensible way of dealing with a case is actually for somebody to make an application for disclosure of the Home Office file of the particular persons and get the court to direct that those files are disclosed to the parties by a particular time limit, because it is embedded in the immigration file and all of the documents pertaining to the case that one can see the sorts of information that you need to understand the history, the immigration history, but also the potential options for the future. And I think in all of these arrangements about contacting the Home Office, you do have to think about privilege. It sometimes shocks me, really, to just see how dramatic can be the difference between the history given by an applicant in their immigration case and the history given by the same applicant in their family case. So they're often diametrically different accounts. And I think that it behoves everyone, where you have got that immigration context in the case, and you may have to deal with the Home Office, that it's important to warn the client that this sort of overture to the Home Office is going to bring to light stories and accounts and witness statements that they've made in their immigration cases. And the sort of consequences of that, because now the Home Office is really vigilant about and really rigorous in either prosecuting or removing in cases where you have a marked immigration deception, and it could certainly affect any future application that the person might make. The other thing that I think about involving the Home Office is that there are some relatively recent cases where you've had a really helpful involvement of the Home Office. So in some cases it may be sensible to invite the court to make a direction asking the Secretary of State to consider intervening and becoming a party, or at least intervening and making submissions and making information available. One of the cases that I mentioned in the short notes that I did for today's proceeding is a case of KB and RJ. It was a parental order case where you have a child stranded in India, where the parents, without any legal advice, had made completely misconceived entry clearance applications, and the child had been repeatedly and properly refused. And you have a judgment by Ms. Justice Russell, where she has indicated that really the court shouldn't make a parental order unless the parental order reporter has had an opportunity to see the child here with the parents. So if you have the child stranded abroad, you have a limping case in that sense, in that there's no capacity to get the welfare part of the case dealt with. And in that case, Mrs. Justice fourthly agreed to set a preliminary hearing, and to have that preliminary hearing dealing with all of the issues about the Section 54 of the Human Fertilisation and Embryology Act, to see whether or not those criteria were met, and to give a short extent a set of findings about those criteria being satisfied, and then adjourning the final hearing and the welfare assessment to a fixed date, and allowing the Home Office to have the time between those findings being made and the final hearing set to reconsider whether or not the child ought to be granted entry clearance. And in each of those cases, some of which I've been involved in, it has worked wonderfully. The Home Office has been very engaged and cooperative. The various directions have been made about the Section 54 criteria are met, and the visa duly granted before the final order, so a welfare report can be undertaken. And it seems to me that case and others that you can see is that the Secretary of State is comfortable if her jurisdiction is recognised and respected, so that you do have, in a sense, this very clear canvas in which each of the parties, to get to the final order, you all have a different part of the exercise to wrestle with. But there isn't any straying into the part of the jurisdiction that belongs to, in this case, the Secretary of State. And the other case, again, a recent case where these issues arose is in the context of a wardship case where you had an unlawful retention of a child who, the child and mother having been granted refugee status on the basis of claimed domestic violence. And then you have the father coming to this jurisdiction seeking to ward or in fact warding the child and seeking an order that the child be returned to the home country. And again, on the direction from the Court of Appeal in the case of H, the Secretary of State was invited to participate. There was the Joint Council for the Welfare of Immigrants was also a party, and of course the parents and child were all represented. And the issue for the court was whether or not the child's refugee status was a bar to his removal. And the consensus view of all of the parties was that it is a bar to removal. But that again, you have another hearing. So the Secretary of State is there. Most of the submissions of the Secretary of State were accepted by all of the parties as well as the court. And what you then set up is a further hearing where the facts upon which the refugee status was given may well be contested in the family court, and the court may take a view that the mother has told lies and that there isn't in fact any risk to either her or the child in the home country. But then again, the consensus view was that it would then go back to the Secretary of State to consider revoking the refugee order, the refugee status decision, and if there was no revocation, then again the child is not able to be removed. Can I say that one of the reasons why these things are really significant is that the Secretary of State's decision about refugee status is not simply a decision about which of the parties, whether the mother is in fact telling the truth, but you have quite a different analysis in a refugee processing system than you have in the family court. You first of all got a much lower standard of proof, so you don't have balance of probability. you have a real risk of harm. And the most important decision, or the most important component of that refugee decision by the Secretary of State is the decision based on country evidence, which is rarely accessible and available in quite the same way to the family court, that if there is a risk, that the child and the mother can't get effective protection from their country of nationality. So it's really a decision that is within the expertise of the Secretary of State, because it's not simply about which of the parties may be giving a truthful account, but whether or not a particular country is affording the appropriate protection to one of its citizens, and that is very much a question within the clear bailiwick of the Secretary of State. The other reason why I think you will find in future the Secretary of State pulled into cases. And at the moment, the only cases in which there is a practice direction for the Secretary of State to be invited to intervene is in adoptions where the child will obtain British citizenship. And that is because those family cases have the unusual effect of changing the civil status of the child and making the child no longer subject to immigration control. But one of the features of legislation in both the Immigration Act of 2014 and then again in 2016 is to set up what Parliament has consistently called the hostile environment. And it is a hostile environment that is beginning to have, and will in future, if it is all brought into effect, will have a significant impact on family cases in the family court. Because what this hostile environment does is that anyone who needs leave to remain and doesn't have it, and there can be a whole lot of reasons why you don't have leave. You can be born in this country and not British. You can be a child brought in as an infant and whose parents didn't ever get their status regularised. You could, of course, be somebody who made an application and the Home Office has treated it perhaps wrongly as invalid, that you were there then without leave. In all of these cases, there's a whole series of services that are going to be denied to you. You can't have a bank account, and your bank account has to be closed. You can't drive a car. You can't take any employment. And more particularly, your landlord or your co-tenant is liable to criminal prosecution if they continue to lease or allow you to remain as a rental in their property. So you are going to have people rendered homeless, and we're already seeing it in some of the jurisdictions around the country where these rental provisions are in force, where people are being made homeless not because they can't afford to pay rental in the private sector, but because their immigration status doesn't entitle them to rent from anyone other than a local authority. And so you will have the local authority forced into housing, or, and what my prediction would be, you have a whole lot of family cases in which, as a preliminary matter, you're going to have to invite the Secretary of State to be at least a participant briefly in the case in order to commit the person to rent or to be a lessee of a rental arrangement during the term of the family proceedings. So this enmeshing of these family and immigration issues and family and immigration decision making, I think, is going to be loom very large indeed when all of these hostile environment provisions come into force. The further question, I think, to consider in these family cases is not simply to whether or not you deal with the Home Office and arrange to either provide information to the Home Office or seek information from the Home Office, but also whether or not you involve the immigration tribunals. And in the paper, I mention a number of cases. In fact, Lord Justice McFarlane was one of the key judges in 2 of the cases where he sat with the then president of the Immigration Tribunal, and they gave guidance on how to deal with these intersecting cases when you have the same family that has got an appeal in the immigration tribunals and they're also litigating in the family jurisdiction. Now, these are very often cases where the person is facing deportation or removal. They have a genuine and perfectly proper desire to get a contact order with their children. And of course, getting a contact order can be a basis upon which they are entitled to then get a visa and remain in the UK. So it is an important immigration right, it's an important family right. And there was no proper arrangements for these cases. So one of the key parts of the guidance was to say that that the immigration case should go behind the family case, so it should be stood out, and the hearing on whether or not the parent should be removed should await a decision on the family case as to whether or not a contact order should be made, and indeed various findings about the child's welfare and best interests. And that tends to happen. That's fairly, unless the immigration tribunal considers that the case is entirely without merit and was just brought in as a sort of a mechanism for delay, then they will almost certainly stall the case to await the decision in the family matter. The other part of the guidance, it sets up arrangements for disclosing information across the two tribunals. And in my experience, looking at both jurisdictions, there's very little of that exchange of information. And I have actually rather more caution about whether or not that is appropriate. Certainly, as a lawyer, I think you've got to really make the decision as to whether it's in the interest of your client for some of that information to be exchanged as between the two jurisdictions. So you may well have applications that exchange should not be made. But I also think that that in other cases that exchange of information is going to be extremely helpful. And probably the best way of dealing with it is to leave it to the parties to decide themselves whether or not they want to ask a court in the family division to agree for certain of the documents to be disclosed either to the Home Office or to the tribunal. But to have the decision made, I think, by judges, and as in communication between judges in the two jurisdictions, I think potentially could appear to be a problematic exchange and communication that's outside of the control of the parties. It seems to me always that people working in the family division ought to be, particularly where there is an immigration side to the case, need to be alert not simply to the issue of disclosure, but also to the question about what you put in a preamble to an order, or whether you ask the judge to make a short extent judgment setting out findings, so that they can form part of the deliberations in the immigration tribunal. In the case of Mohan, that went to the Court of Appeal, and which looked at these two tribunal cases, RS and Imato Boateng, where the guidance was given, in Mohan, the court made the observation that, first of all, the guidance is set down by the two judges who have considerable experience in each of the jurisdictions, but also the family court is in a much better position to deal with issues about the welfare and best interests of children. The immigration tribunals are really handicapped in the resolution of those issues, and the current president of the immigration tribunal has said repeatedly that you have got to have an utterly rigorous, detailed evaluation of the sorts of matters that are germane in family jurisdictions, because those are the matters that are key matters in terms of evaluating welfare and best interests. And you have exactly the same duty imposed on the Secretary of State as you have on all local authorities from the Children Act of 2004. So the supporting and promoting welfare are identical obligations in both jurisdictions. And so those findings from the family court, where they've heard from both parties, where they've heard from professionals, where they've got professionals who've got considerable experience in child welfare, child development, child attachment, all of those things that are key issues in a removal or a leave to remain application, those are much more sensibly dealt with and much more fully exposited in family cases. And certainly if those findings and the evidence on which they're based are made available in the immigration jurisdiction, in my experience, they always have a considerable weight, not simply for the tribunal and the judges in that tribunal, but also for the Home Office at first instance. And their own policy suggests that these things should be given considerable weight. Now, I just wanted to really just have some suggestions for the sorts of things that lawyers in the family cases need to be alert to when you've got an immigration matter that is potentially there or is actually on foot in the immigration tribunals. I think that there is going to be a really significant issue for people post-Brexit, if indeed people, we're no longer part of the free movement arrangements of the EU. And what I think Brexit brings home, certainly to lawyers in the immigration jurisdiction, is the real importance of giving proper consideration to the nationalities that a child may have and that a child may wish to exercise when they are adults. So if you have a child born in this country who's got parents with foreign nationality, in all probability the child will have inherited that foreign nationality by descent. And again, in my submission, and I try to advise this in many of the advices that I give in the family matters, is that it's incredibly important to not only think about the nationality, and take advice about which ones may be available and accessible to the child, but also how to access them. And in many of the citizenship by descent, you need to register the child's birth, and sometimes register the child's birth with their consulate within a particular time span. And if you don't, the child may in fact lose the capacity to have that citizenship. You also have to check whether or not the country, the child's citizenship by descent is from a country that allows dual nationality even while you are a child. So many countries allow children to hold dual nationality and then requires them to elect when they turn 21. But get those nationalities for the child so that when they do turn 21, they have the options to adopt the civil status that is commensurate with the future that they want to live. And it's also important, particularly where children are being removed from their family, that you get them the sort of documents that will allow them in future to prove their citizenship. So it may be the birth certificates of parents. So in care proceedings, it seems to me that in care plans, there's a whole lot of things that are never put in a care plan that really ought to be there. And post-Brexit, when we're much more alert to the need, the rights of travel and the loss of rights to travel, things like getting the birth certificates of parents, getting notarized copies of the parent's passport. These things can be held for the child so that at the age of 18 they can apply for a passport in whatever country they can assert their nationality. You need to regularize the child's immigration status. And I know from my chambers that there's been a number of cases where they have sought damages against local authorities for failing to regularize the immigration status or regularize the nationality status of children while they are children and while they are either looked after or children in the care system, because that failure can have a very real impact in adulthood, with the child being liable to be removed when they turn 18. And it's important for local authorities and family lawyers to know that there is a provision in the British Nationality Act, Section 3.1, that allows the Secretary of State to register any child as a citizen if he thinks fit. That is the wording in the provision. So it's a very broad, it's one of the
rarest of provisions in nationality and citizenship and immigration law that preserves this very untrammeled discretion of the Secretary of State to just call someone a citizen. Those of you of my vintage will remember the Zola Budd case, when she was given citizenship in order to be able to run barefoot in the Olympics. But in any event, those are very significant mechanisms for children. And under Home Office policy, they suggest that children in the care system can be registered as British citizens if social workers indicate that they consider the child's future to be in the UK. So you have very many of these really vulnerable children, and you have the mechanism through a care plan to consider a child's identity rights, their civil status rights, and the sorts of procedures and mechanisms that that really ought to be put in place for them. And just before concluding, yes, there's two more things that I wanted to say. Is that one other reason for getting this done for children, while they have the advantage of local authority involvement, it's just the cost of these immigration applications. Currently, if you were two parents and two children applying for leave to remain in the United Kingdom, you would probably be spending £7,000 to make your visa application. And because the child is also the children whose cases are not considered in any sense separately from their parents, nevertheless are charged the full visa application fee. And they also have to pay £200 per year for both children and adults as an NHS surcharge. So if your visa is for 5 years, you pay £1,000 for getting a visa of that length to cover the anticipated NHS costs for that period. So to have the local authority engaged and getting those applications for a child as a child, and while the child is in their care, can mean that the child has got secure status, that their parents, even if they were returned to their parents, that their parents simply couldn't afford to make that application on their behalf. And a recent study by Islington Law Centre just showed the large numbers of these children brought in to this country as children, but who have irregular and unresolved immigration status, who are really vulnerable to removal at the age of 18 because no one has stepped in to regularise their status during their infancy. And then the last thing that I wanted to mention, as the other area where you do get a lot of crossover arrangements are in trafficking cases. And again, that is a case where you have, first of all, an obligation to refer any child that's considered to be a potential victim of trafficking to the national referral mechanism, which is, if the child is a foreign child, is the referral mechanism in the Home Office, where their status as a victim of trafficking is to be determined. And again, you see in numbers of the care cases, actually I must say I get enormously impressed in seeing the trouble that local authorities are taking with trafficking victims and the efforts that they go to provide the sort of, not just the protection, but also the recovery arrangements that many of them need if they've been actually exploited or abused as a trafficking victim. But the other thing to remember is, that, again, that as a trafficking victim, there is a mechanism in the Anti-Trafficking Convention, the Council of Europe Convention, that has become part of Home Office policy for those victims to be granted a term of stay or a term of leave. And generally, the Secretary of State's view is that unless there are adequate care arrangements in the country of nationality, children are allowed to remain here. They're given leave to the age of 17 and a half, so that in that last 6 months, the Secretary of State can consider whether to allow them to stay, and if not, have them ready to be removed on the dot of turning 18. So it's a very, it's a harsh process for these children, many of whom have had all of their infancy in the UK, and whose capacity to remain very often requires the involvement and assistance of lawyers and social workers and other professionals who can indicate to the Home Office as well as to a family court the sort of attachments, the sort of identity rights and interests of the child over that extended period of time. I think I will finish there, and we can